Hello, this is Michelle Ogborne with Ogborne Law, and today we're going to talk about what makes up an effective estate plan and why it's important. First, I like to divide the issues into three buckets. The first is property, the second is healthcare, and the third is children if this applies for your family. So when we talk about property, we have several documents that determine what happens to your property if something happens to you. The first is what you're typically used to hearing about, which is your will. The second is a trust. The third is a personal property list. And the fourth is a financial durable power of attorney. Each of these documents accomplish a different goal, and depending on what your needs are or your family's needs will dictate which of these documents you need. The next one we look at is your health care. Within that, we have your living will, which lays out what your wishes are for life-sustaining support, your medical power of attorney, and your Hippa authorization. And again, the last bucket is your children. If you have minor children, we need to look at guardians, who's going to take care of your children, and who makes money decisions about their care. So why is estate planning important? Estate planning allows you to create a comprehensive plan to accomplish your wishes and give you peace of mind if something happens to you. It's the only way to ensure that your family knows what your wishes are and that those wishes are followed if and when you pass away. So I'm often asked, what is a living will and how is it different than a healthcare power of attorney? A living will is your legal document that protects your end-of-life medical care decisions. It tells your healthcare power of attorney what your wishes are if you are in need of life-sustaining support. For example, if you have a health issue or you're in a catastrophic accident and you're in a coma and it's machines that are needed to help keep you alive, what are your wishes? One of the things that you can do by having a living will in place is you make it easier for your family to make a decision about when to continue life-sustaining support versus terminating life support. In those cases, your family is choosing to honor your wishes versus giving up on you. So I tell my clients it's really important that you have this document in place to make it as easy as possible for your family if they're facing this decision. Now, often I'm asked, what is the difference between a living will and a healthcare power of attorney? As we mentioned, a living will is the document that lays out what your wishes are, but your healthcare power of attorney is a document that designates someone that you trust to actually carry out those healthcare decisions on your behalf in the event that you're incapacitated. So both of those documents are valuable and are needed to make sure that your wishes are honored and that the person you want making those decisions for you has the power to make those decisions. The other documents we look at is a durable financial power of attorney. This document is different than your healthcare power of attorney. Whereas the healthcare power of attorney gets to make decisions about what type of medical care you receive, your financial or durable power of attorney is actually the person who makes the decisions about what medical expenses are paid for, your mortgage, your utilities, etc. So you need someone to be named for both of these powers in order for them to be effective if something happens to you. For some of my clients, this is the same person. So, for example, the person who makes the healthcare decisions is the same person who will be responsible for paying the bills. For other clients, they are different people. There's a lot of different factors to consider, and if you want to learn more about that, you can check out one of our other videos where we talk about the things to think about when naming a financial and healthcare power of attorney. Another thing to consider is your Hippo Waiver. We want to make sure that the person who's making healthcare decisions for you actually has the ability to get access to the necessary information needed to make that medical decision. So whether you have a freestanding Hippa authorization or it's contained within your healthcare power of attorney, it's very important that you make sure that this language is included to ensure that your healthcare power of attorney can get the information needed to make the best medical decisions for you. It's why I tell a lot of my clients they should make sure they work with a licensed attorney who practices in this area to make sure that their wishes are carried out to the fullest extent possible. The final document that we're going to talk about is your revocable living trust. This is what people think about when they talk about avoiding probate court and making sure that the process is as easy as possible for their family. So where a will tell the court, here's who gets what of my personal property, the only way to avoid a court process and a judge overseeing the process of distributing your property is to execute a proper legally binding living trust. So a lot of my clients will come to me because they want to make sure that it is an easy process for their family if they pass away. They don't want their family to spend a lot of time, energy, and stress in the court system or have a judge oversee the process. They want to leave clear instructions and, again, make the process as easy as possible. A trust is the only way that you can control the distribution of your assets after you've passed away So for example, you can designate certain ages at which your children could receive assets or other beneficiaries. You can also determine what additional money they have access to for different types of life events. Again, a trust, you can only do that via a trust. A will, they would get the money outright with no strings attached. Again, a trust is also the only way to avoid the probate court process. So I'm often asked, why does it matter if I have an estate plan in place? And I tell people the reality is you have an estate plan. It's either the one you put into place or it's the one that the state of Arizona has in place for you via the laws of this state. So the thing to consider is if you choose not to put an estate plan in place on your own, what it means is the state of Arizona gets to decide where your property goes, who gets your money, who is responsible for the medical care you receive and what care you receive, and who gets to care for your children while a judge decides who should be the final guardian. Only you know if this is something you're willing to risk and be okay with, is the state of Arizona's plan versus the one that you put in place for your family. So thank you for watching this video. If you found it helpful, please hit the like button and subscribe to our channel for future videos. And if you want to learn more about some of the areas that we talked about, I encourage you to check out our other videos. Otherwise, we hope you found this useful and we look forward to seeing you soon.